You're rebutting?
I'm assuming questions from landowners or land agents or the IUB or whoever.
But otherwise you don't know.
I'm going to have to defer to my attorney.
Well, who drafted your rebuttal testimony?
Who drafted it?
Yes.
Myself and the summit attorneys.
Okay. On page 6, line 14 of your rebuttal testimony, if we can get that up. You said that Summit engaged you early in the pre-permitting design phase, and that allowed you to collect substantial amounts of information. Can you give us a better idea of what you did to get that information and what kind of information you were looking for?
We were gathering existing drain tile maps, not only from landowners, but from counties, NRCS offices, drainage districts, to make sure that we understood the impact and made sure that the pipeline was, taking into consideration where the drain tile was to have the least amount of impact as possible, and then being available to answer any landowner questions along the way, provide input at public hearings, any way we could support answering questions about agricultural drain tile on the project.
Did you go out to any landowners' land and look to see what you could find?
We've had meetings with landowners. I mean, it's really preliminary right now as we're still in the permitting process. But yeah, we've engaged and answered lots of questions along the route with land agents.
Okay. You mentioned drain tile maps. It's my understanding from hearing from landowners that there is some drain tile that was installed years ago, like in 1920s or 30s, but there's no map for, and nobody knows exactly where it is. Is that your understanding?
Probably, yes.
Okay. So what would you do to try to locate or determine where that kind of tile might be?
Before the project starts, we use aerial imagery. We do different analyses of low spots, talk to the landowner about where he feels the tile may be. During construction, we have field engineers on site that are spotting tile as the trench is opened up.
Do you think that's good enough to find that unmapped tile?
I think so.
Or at least minimize damage to drain tile.
We address any concerns or issues they have in the county we're working in, or areas they have questions on. Work with them to ensure that anything that they see as a problem or a potential issue for landowners addressed correctly.
Is your agreement with Summit that your company at least, would be on site as the trenches for the pipeline are being dug and the pipe is being put in the trench?
Yes.
All the way along the route?
Yes.
On page 8, line 11, of your rebuttal testimony, I think you were talking about pattern tile there, is that correct?
Yeah, I think the question was, there's a lot of repairs in the field. That's pattern tile. How do you handle that?
It goes back to the previous question, I think, and it's a follow-up about pattern tile. So give us a better idea of, first of all, how you could avoid, perhaps, any problems with pattern tile, and then secondly, what the challenges that there would be in trying to repair any damage.
I guess I'd ask for a little bit more clarity on your first question.
Okay. What challenges are there in trying to avoid or minimize the damage to the pattern tile? That wouldn't be there in some other kind of tiling situation.
I guess I'm still not quite understanding the question. I mean, the tile are going to be damaged. They are going to be dug through where the pipeline goes through, and we're there to ensure that they get replaced and fixed, to the same condition or better.
I guess what led me to the question was that in that previous question, it seems to infer that there are particular issues or challenges with the pattern tile that would not be present with other kinds of tiling systems. Is that a fair statement, or am I misreading that?
I think you're misreading that.
Is it better to have the drain tile above or below the pipeline, or does it make any difference?
It's definitely better to have it above. I think there's very few incidents where the pipeline or where the tile will be below.
Okay, so you want the tile above the pipeline. Okay. So you'd have to know how deep the tile is in any particular location, is that correct?
Correct.
And how do you do that?
Most tile systems are installed between 3.5 and 4 feet deep, on average.
Okay.
Pretty common practice in the industry.
Is it possible they might be deeper than that, and you wouldn't know it?
There could be some that could be deeper.
Okay. And so, is it possible or more likely that that tile would be damaged by the installation of the pipeline?
Yeah, no different than the rest of the tile.
Can staff pull up section 479B.31 of the Iowa Code? If you have that access to that. I knew they could do it. Can you read that, Mr. Ellingson?
Sure.
Let me know when you're done reading it.
Okay.
Okay. This is a section of the Iowa Code regarding hazardous liquid pipelines, and indicates a procedure if the landowner installs new tile after the pipeline is installed. Do you understand that?
Yeah.
Okay. And that any additional costs for installing that new tile system that would be caused because of the presence of the existing pipeline shall be paid for by the pipeline company. Have you ever been involved as a consultant or expert in a situation like that?
No.
Okay, thank you. That's all the questions I have.
Sure. Thank you.
Mr. Meyer, did you have a follow-up? Just double check. Okay. It's okay. I don't believe the board has any questions. Mr. Leonard.
Just a quick redirect, Your Honor. Mr. Ellingson, there were a series of questions related to page 8 of your testimony. I just want to ask for a clarification. When you're talking about something like a header system that you would put in ahead of time prior to construction, is that something that Summit would pay for?
Yes.
Thank you.
Okay, any questions on the redirect? Okay, seeing none, Mr. Ellingson, you are excused.
Thank you.
We'll go ahead and take a 15-minute break and then move on to we'll find out.
As I suggested at the end of the day yesterday, unfortunately, Mr. Ellingson is the last witness that we have available today. We have several that will be here tonight that can be ready for tomorrow. Aaron DeJoya, who I think we need to get in and out. We are actually filing, should be coming into the board system now, the ordered dispersion information. And I would suggest that Mr. Powell will be available if you want to put him back on the stand tomorrow. He will be unavailable at the beginning of next week because of the start of the South Dakota proceeding. And then, who else do we have tomorrow? Yeah, and Micah Rory will be available tomorrow as well. We were thinking we would run a little later today, but the issue with Mr. Rory is he actually is participating late today in a mediation as set up by the board. So.
Okay, hold on. Mr. Jorde.
Well, yeah, so, I mean, I've got a real problem with this. I mean, it's their case, and they might have a order that they prefer, but they're on the clock, and they need to have witnesses here. So if they don't have a witness, I would move that I'd request an order that their case in chief be ordered closed, since they don't have a witness and we're still here, and that their case presentation be over, and then we can move on to the next party. And short of that, I want to discuss the motion that I've filed on this scheduling. Again, I mean, we have enough time to get a whole nother witness done, but they're not here, which puts pressure on tomorrow, and which puts pressure on the rest of the proceedings. And as it is no mystery, as it hasn't been for 6 months, I have to be in South Dakota all next week, Monday through Saturday. And I also need to cross-examine all of the Summit witnesses. So I'm requesting that if we don't get done with Summit witnesses tomorrow, Friday, that these matters be stayed until such time as the South Dakota proceedings conclude, in which case the same Summit witnesses and myself are going to be up there. So that's my request. None of this would have been a problem if we would have stuck with what was discussed, and these matters would have been scheduled in November or after. And so it's a serious problem that the board prior to the newly constituted board was aware of and has been aware of, and it's never been a secret.
Do you have a statement?
Your Honor, we had requested dates that would have been well before the South Dakota hearing. Mr. Jorde, knowing when the South Dakota hearing was scheduled, pushed for a slower schedule in this proceeding, and he did that knowing the South Dakota hearing was out there and took that risk. Contrary to Mr. Jorde's motion to stay, as I mentioned yesterday when he was not in the room, we neither had any advance notice of the proposed schedule, nor are particularly the non-party witnesses at our, quote, beck and call. I think the board is aware that we've been scheduling with very short turnaround. It was Labor Day weekend. We couldn't necessarily get flights in for some of these non-party witnesses. We have tried to keep things moving despite that as best as possible. But we don't have control over how long each witness goes. That is largely in the control of the other attorneys in the room. We will have people in tomorrow. I would note that Mr. Williams seems to have done a perfectly fine job here in Mr. Jorde's absence, and that staying for the entire length of the South Dakota hearing is impractical and simply is not necessary.
Okay. We are going to take a 15-minute break, and we will come back and address these. I will say before the break, it is somewhat frustrating that we can't continue and that we're leaving some perfectly... Oh, Mr. Long, did I cut you off? Nope. Thank you, Mr. Whippel.
I would just suggest that we all think on the 15-minute break about the witnesses after Summit, and we're willing to be flexible if other parties have timing needs for their witness.
Thank you. Appreciate that. Okay, take a quick 15